trial that started. And then had September the 5th, 30th.
Bro is not happy today.
I don't even understand what frequency you are. I mean, this is a death penalty.
And Judge, the heightened
No, now it's my turn to talk. So you all decided, for someone who's already facing capital charges, let's open up a new case. You could have done all this the day after his murder trial was over. You could have done all this.
Oh, YNW Melly appeared in court for motions and goes against the advice of his lawyers. Melly is seen snapping at his lawyers over the stay in the case. It seems Melly doesn't want any more delays himself, but his lawyers advised him to keep the stay on the case and delay the trial. The state wants to delay the trial as well. You're going to see what the judge does towards the end of this video. If this trial gets delayed, it wouldn't happen until 2027. That's what the judge says. Watch the full video, hit subscribe, let's go. All right, stream cuts on late. So we're out of scene. Melly's lawyer's already talking. And here's Mr. Griffiths from the state and the judge. Let's go.
2019, rather. Mr. Demmons voluntarily surrendered and was charged with 2 counts of first-degree murder. In October of 23,
I'm sorry, this guy's face right here.
Mr. Demmons was rearrested for tampering with a witness, directing the activities of a criminal gang, solicitation to commit tampering, and conspiracy to commit tampering. As a result of that, the state provided supplemental discovery in the murder case and represented to the court on numerous occasions that the tampering case is intertwined with the murder case, and they expect to introduce evidence of the tampering case to a certain extent for consciousness of guilt.
Yeah, we've known about that. They're trying to show Melly was trying to silence his girlfriend. Remember the whole coded language bullshit. He's guilty. He's trying to hide witnesses from the court, blah, blah, blah. You get the picture.
A year transpired, and in December of 2024, the defense learned that a search warrant was executed on a member of the defense team's Apple account, Miss Liberty's. And they withheld that evidence for over a year. And I would submit to the court that had not Apple notified Miss Liberty a year later that a warrant was executed, the state probably would have concealed that point as we stand here today.
Still crazy to me. We already know all this. Everything, the entire iCloud account was taken by the state of a lawyer.
And the court originally indicated that the state was to produce to the court the affidavit and the warrant. The following day, the court modified that and told the state to produce a copy of the warrant only to the court, and that the court would, in fact, do an in-camera inspection of that warrant and decide whether or not to reveal a portion of that search warrant or the total search warrant. On January 14th, before the court ruled on the warrant, the state filed a memorandum of law regarding attorney conflict, setting forth that regardless of if Mr. Demmons wants to waive any potential conflict, the court must basically throw her off the case. And they cited various case law, and I agree with the state that the court does have the inherent responsibility or authority to remove an attorney based upon the nature of the conflict. I agree with that, and it's been done in state court and it's been done in federal court, so we're in agreement with that portion of it. As we sit here today, 18 months later from the execution of this warrant, Mr. Demmons does not know the full extent of the conflict, nor do the lawyers know the extent of where this conflict exists, other than they executed a warrant on Miss Liberty's Apple account.
Seems a bit unfair, right? I mean, this guy is facing the death penalty, and we don't know if one of his lawyers is going to be arrested at any moment. And the trial's in 2 months or 3 months.
In July of 2025, saying that she must get off this case. And if they really believe that, they should pursue that, because that would be the first issue on appeal if he's convicted of anything.
Damn. They're like, we're already going to appeal this shit. That's the first issue right there if he's convicted. I mean, we all know if Melly is found guilty, there's going to be some appeals, right? Like, there's going to be a whole big process, bro.
And I suggest that the court should hold a hearing on that and divulge the extent and what the conflict really is.
For the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
For over a year, the state came into court and said it's an ongoing investigation. And as a result, they are allowed to conceal that, and it doesn't come under the discovery rules to provide that information. And the court in its order, and I think paragraph 4, stated, this court does not agree that the search warrant is part of an ongoing active investigation.
So they lied. The judge is calling them out that they lied. Remember that?
As of January of this year, Miss Liberty has not been arrested, nor is she a defendant in any pending prosecution, despite the fact that the state has had this information for over a year. Well, they now have that information for over 18 months, a year and a half, and they're still alleging that it's an ongoing investigation. The interesting thing about Your Honor's order, everything was interesting, but you gave the state an opportunity to appeal Your Honor's ruling and said, I would not divulge the warrant.
And they didn't appeal it. You gave them a time frame, and I'm pretty sure they did not appeal it.
You have until February 7th, 2025 to appeal the finding of this court that this is not an ongoing investigation. They did not take an appeal. And I suggest to the court that the law in this case, as we stand here today, is that there is no ongoing investigation as it relates to anybody in the defense team.
There's first look at Melly. That boy's smiling, like always, looking over at his family.
A continuing obligation to disclose any information that would lead to relevant information. They have not disclosed the affidavit. They stand here today and say it's still an ongoing investigation.
Raven Liberty and his mom have not spoken. They're not on good terms, so that's pretty awkward.
And one of the definitions is it's something that will occur soon, at a time that is not long from now. They've had 18 months to sit on this, and they've done nothing except come in here and conceal this to the defense. I don't understand that. If they say it's foreseeable, when? When are they going to take action? 18 months is a long time for us to sit here and worry about what's going on. Now, I do thank the state for citing the Hill case in their memorandum, their addendum, because in the Hill case they said, the appellate court said that the court was right in not disclosing the affidavit because the charges of Mr. Hill were different than the charges that were based on the search warrant. And they said it would not lead to any fruitful or relevant information. The search warrant in this case, tampering with a witness on a capital felony and directing the activities of a criminal gang, which is exactly the same charges that Mr. Demings faces in the tampering case, and which they come into court every time we're here, and it's brought up, saying we're going to use some of that evidence in the murder case. They can't have their cake and eat it too, Judge. As we have said, this case is different from most cases because death is different. If Mr. Demings is found guilty of these charges, he's looking at the ultimate penalty of death. The rules provide that they have a continuing obligation to disclose all information that could lead to relevant information in a timely basis. As we sit here today, we're 2 months away from trial. We've waited 18 months for them to disclose it. We attempted to bring in Detective Luna.
Detective Luna was the detective that, on a deposition, she refused to answer questions, and Mr. Griffiths, the one standing right there, stopped this detective from answering questions with the ongoing investigation and said the judge was wrong. Straight up said, the judge is wrong. There is an ongoing investigation. We're not answering questions in this deposition about that.
Despite Your Honor holding, this does not qualify under the statute as an ongoing investigation. They said, Your Honor was wrong, period. Now, I got to tell you, that takes guts, in my opinion. That takes a hell of a lot of guts for a lawyer to come in here when they had an opportunity to take this up to the higher court and say you were wrong and do nothing, absolutely nothing, except impede our investigation to properly prepare for trial.
I used to have a big, ugly brown wallet that would take up so much space in my pocket and would always fall out. But over 6 years ago, I got sponsored by Ridge and I've never used another wallet since. And I haven't been sponsored by them in years. And I've continued to use it because it's actually a great product that I recommend every single one of you having. This is a compact, high-quality, slim wallet that holds up to 12 cards plus cash. And no expense is spared. They use high-quality materials such as carbon fiber, aluminum, and titanium. And they have over 50 colors and styles to choose from. And I know you watching this video right here have lost your wallet before. Well, consider that problem fixed because you could have the Ridge AirTag attachment. You can put an AirTag on the back of your wallet that tracks your wallet. And look how skinny this is. It takes up no space in your pocket, bro. It's absolutely incredible. And Ridge doesn't just make wallets. They also make premium everyday essentials like key cases, suitcases, and rings. Ridge has free shipping, a 99-day risk-free trial, and a lifetime warranty on all their products. For a limited time, our listeners get 10% off at Ridge by using code CUF at checkout. Just head to ridge.com and use code CUF and you're all set. After you purchase, they will ask you where you heard about them. Please support the show and tell them it was me. Use code CUF 10% off. Great product I've been using for over 5 years. I'm telling you boys, even without being sponsored, I continue to use it. Then guys, back to the rest of the video.
And it really doesn't matter, in my opinion, because nothing has been done. This is not an ongoing investigation that will lead to foreseeable criminal charges against Ms. Liberty or anyone else. These are the exact charges. The basis of this search warrant are the exact charges that this young man is facing and going to be used against him in the murder trial. How in the heck can we defend that? How in the heck can we sit down with him and explain to him the conflict? Because we don't even know the nature of the total conflict, other than an allegation that they executed a warrant on Ms. Liberty's account. That's all we know. Nothing else.
Not only interrupt your argument, but I thought I also ordered the state to turn over everything that was obtained as a result of the search warrant.
You did, but they did not give us all. And it's my fault that I didn't file an additional motion. They only gave us one phone line, 2 phones. There were 4 accounts listed, and they only gave us 2 accounts.
Interesting. So they did hand over shit, but only half of it, it sounds like. And this is a reoccurring thing with the state, that they keep not handing over everything the judge orders them to hand over.
I don't know how we can properly defend Mr. Demons on the evidence of tampering with a witness, solicitation, conspiracy to tamper, when we don't know all the facts. So I would ask the court to inquire from the state, if this is truly an ongoing investigation, when is it going to come to a head? Today, tomorrow, or in the middle of this trial? And how come you have not pursued, when you file a memorandum of law, saying that Ms. Liberty must, regardless of what Mr. Demons wants, regardless of what the defense team wants, must get off this case? I don't know how they can do this. So I'm asking Your Honor to not only compel Detective Luna, because we agreed to recess the depot, to answer questions about her participation, but also to produce that affidavit forthwith.
Oh boy, Mr. Griffiths right here from the state is about to respond. Here we go. Yep, Melly's mom is there.
That's the bottom line. They totally ignored Your Honor's order when you gave them every opportunity to appeal. Thank you.
This has been an ongoing problem. I thought I had previously explained this to the court and counsel. I will do it again. The 23 case, the tampering case with which Mr. Demons and his co-defendants are charged with, has nothing to do with the Apple iCloud investigation. I believe we even said in court that anything that came out as a result of that iCloud investigation would not be used in his homicide trial. I think we made that very clear to the court. They're completely separate entities. So the fact that they're imputing what's happening in the 23 case and we intend to use that in trial, and I believe we filed a motion, that remains true. But that investigation has nothing to do with this. This is actually a separate investigation stemming out of a separate incident. The court twice previously has refused to turn over the affidavit, meaning the court has refused to let the defendant and his counsel know the nature of the investigation. I stand before this court today, it is still an open investigation, which is why I filed the motion for in-camera hearing. Because the court also pointed out last time when we were here that you had not taken any testimony, and so the only decision that you can make that whether it was an open investigation or closed was the fact that only time had passed. I included in my motion the fact that there is case law that states that there is no time limitation on how long an investigation can take. They take as long as they take. I'm sure the court's aware that investigations involving like embezzlement and other crimes take longer other than like a simple delivery case. I still take that same position I've taken before, which is outlined in my motion, that they have brought forth no new facts, no new issues, whereas the court has previously denied this issue, denied them the affidavit, denied them knowing what is going on with this open investigation. And so they bring nothing forward to the court today, so really the order of the court stands, which is they're not entitled to it. We again are prepared to take that next step, conduct the in-camera review, so the court can have an insight into the nature and the state of this investigation. We didn't feel that a hearing or an in-camera review to make that determination was necessary, but again, the court already ruled on it, and we simply provided the court with a memorandum of law. So at this point, they provided nothing new to establish why they need to know the nature of this investigation and where it is and what's ongoing with it. I understand everybody's frustration, it's taking a long time, but the rule, the case law allows for that. So where they are now is they have access to the warrant. We're in a similar position, just like the Hill case, where we dealt with a confidential informant in an ongoing investigation, and the court, even without conducting an in-camera hearing, said, because this doesn't deal with anything related to the affidavit, there's no need to conduct it. He's charged with something separate. Mr. Demons is charged with something separate. And so candidly, there's no point for even an in-camera hearing. It just needs to be denied outright, but we're still prepared to do that in-camera hearing.
So you're saying none of this is necessary. It's a completely separate investigation. We're not going to use anything that was found on Raven Liberty's phone or anything in the murder trial. This whole thing is just, I still can't believe this is just taking this long. This trial just needs to come. And I hope to God he's not delay this trial, because that's what the state wants, by the way. They want to delay this trial.
The state's position and why we have been at this point during the previous court hearings.
Is Detective Luna and a witness in the murder?
She was not listed originally. What we didn't know actually came out during the depot is that she was a training officer when Mr. Henry brought the bodies to the hospital, and one of her associates actually ended up writing the report. She didn't write any reports. We actually didn't even know she was on scene until she came into the depot and informed us she was there.
Yeah, that's something we all found out. When I read the deposition, I was like, wait, what? She was at the hospital when Bortland dropped off the bodies?
She didn't take any active role in it, but she was a supervisor. She was the FTO for one of the officers. And I think at that point we listed her as an A witness because we realized she was on scene. The fact that she doesn't have anything material in terms of the homicide case, we theoretically could change her back to a C witness.
As we're having this hearing, she's an A witness in the murder.
Yes.
Next question. She's an A witness in the tampering thing?
In the 23 case, no.
She's not.
No. She is?
Well, hold on.
Oh my God, which one is it? Griffiths is saying no, she's not a witness in his witness tampering case. And then the other state attorney behind him goes, wait. And now the judge is picking up on it. Is she a witness or not in the 2023 case?
State. You're the one that lists who your witnesses are, so is she a witness in the 23 case?
No, Your Honor.
She's not.
She's only a witness in the murder case because, as I explained to the court, we didn't realize that she was on scene.
Oh my God.
Apparently she was listed as an A in both, but we're going to remove her from the 23 case because
Right now, she's an A witness.
she is, that appears to be listed in error. She had nothing to do with the 23 case.
She was defiant of the search warrant.
That search warrant has nothing to do with the 23 case.
Hold on. One voice at a time. Didn't you turn over state? I ordered you to turn over.
I'm sorry, Judge. She's not listed in the 23.
I understand the parameters of both arguments, okay? I have no control over law enforcement's continuing investigation. That's not even my purview. But what my purview is the heightened due process that's required in first-degree murder death penalty, all right? This witness, Detective Luna, WNA is listed as an A witness. Doesn't matter to me what's going to happen if the state changes their mind because they don't like the results of the hearing. But she's like any other A witness. She has no right to refuse to answer any question.
As to an open investigation, she does. That's the state's position. She can discuss.
Yikes. He's saying because she's an A witness, she has to answer questions at a deposition. And he's saying, I don't agree with you.
She's like any other A witness. She has no right to refuse to answer any question.
As to an open investigation, she does. That's the state's position. She can discuss. Well, then I would ask the court to conduct the in-camera hearing.
So with all due respect, I don't have to. I mean,
Actually, I believe under 3.22, I think the rule says the court needs to.
I probably should choose my words carefully here, but I don't even understand what frequency you are. I mean, this is a death penalty case.
And Judge, the heightened due.
No, now it's my turn to talk. But the whole purpose of this is for him to decide, and by the way, I believe I said this back there, there's a conflict, obviously. And they don't agree with the law. I don't get to decide who Mr. Deming's lawyer is. Mr. Demings gets to decide who Mr. Deming's lawyer is. If one of Mr. Deming's lawyers is not following the professional rules as required by the Florida Bar, that will be an issue between that person and the Florida Bar. As far as the death penalty case, based on all of the very current Florida Supreme Court case law that I have cited on multiple occasions, it's his decision. Because even if there's a conflict, if he says, Judge, I want her to be my lawyer, she gets to be the lawyer. And if he says, Judge, I don't want her to be my lawyer, then she's not going to be my lawyer. That's why I had a discussion with him about this back in February. That's his decision. The reason that I had all these, the search warrant, the results of what they got from the search warrant turned over, none of this should be new information. It's all coming from Ms. Liberty. At least that's what's been represented to me. So she knows what's in it. So she can sit down with her client and tell her what's in it and she can decide. So to that extent, the entire purpose of all of this was to make sure Mr. Demings had the correct material in front of him to make a decision. And he still has to make that decision. His time to do so is rapidly disappearing at this point. But the bottom line is, this is an easy call today because she's an A witness. So A witnesses have to answer questions. That's it.
Boom. Griffiths is like, well, I disagree. It's an open investigation. She doesn't have to answer the questions. Judge saying, fuck no. Yes, she does. She does have to answer questions. Shooting that down.
Respectfully, over the state's objections, over the state's cited case law, over everything. You charge him with a crime. He's an A witness. She's an A witness. She has to come to the depo and answer questions just like any other witness. So your motion compels granted. Just answer whatever questions you want. So I'll enter a separate order regarding that.
Motion to compel is granted.
You're all going to be fighting about this. 250 jurors are lining up outside the door there. So
just so I can
use your time, and that's how you're going to use
So
your
just
time.
so I can.
You're all going to be fighting over this as 250 jurors are going to be lining up out of the door. I'm surprised it's not like 500 jurors. It's going to be pretty hard to find people in Florida that don't know about this case.
Should the court say, no, we're not turning over the affidavit, but we're taking the deposition of Detective Luna, which concerns materials contained in that affidavit, the court's not ordering it turned over, in the state's view, she can still refuse to answer those questions because it will go to that ongoing investigation.
I just don't. Yeah, I'm sorry. I understand what your position is. But listen, who decided to charge him with tampering case? Who did that?
The 23?
Did they do that?
Yes, Judge. No, I mean, no, but I understand where the court's going with law enforcement.
That,
Yes.
right? And the state did that.
Yes.
Okay. So you all decided, for someone who's already facing capital charges, let's open up a new case. Let's charge him with a new crime, which can land him in prison for the rest of his life, by the way. So you're confined to the rules of discovery. I don't know what to tell you. You could have done all this the day after his murder trial was over. You could have done all this.
Boom. They didn't have to do this if you think about it. Because then they're bound by the rules of discovery and they have to give over everything. They can't be hiding shit.
You chose to do it when you chose to do it, so be it.
No, not the 20. But, so the court's clear, for the record. The 23 case has nothing to do with this Apple iCloud affidavit or with what Detective Luna potentially testified to in terms of her work in this new investigation. They have nothing to do with each other.
Sir, if a law enforcement officer hypothetically showed up at my door asking to serve a search warrant on anything that belonged to any lawyer who's currently litigating a death penalty case, I would decline that request and probably ask them to leave the courthouse. Okay, so that's just my view.
Thank you.
Oh, he said I would have not wrote that search warrant if I was the judge. I wouldn't have given her the search warrant that's a lawyer on a death penalty case. So he's kind of shitting on the judge that signed that warrant.
States, anything else that you would want to tell me in support of your motion?
No, Judge, my motion basically covers the previous court's orders, the statute, the case law in terms of how this case is stayed.
Okay. Defense, do you all want the case to be stayed? The state says it's stayed, so should you agree with their motion? Can we not agree with it?
Can we have 1 moment?
Sure.
So state wants the stay to stay in place because of the whole appeal nonsense. They're trying to delay the trial. The state doesn't want to go to trial in September. So that's what's happening here. He seems angry, right? He was snapping at them.
Yes, sir.
Against our advice, our client wants to proceed.
So you object to this? their request for me to determine this automatic stay.
Based upon what our client has instructed us, yes, sir.
What? Melly's going against the advice of his lawyers. He's objecting to the stay. His lawyers didn't want to object to it.
I am aware that 924-071 calls for an automatic stay while the state is appealing some orders they want to appeal.
They were aggravators. They go to membership in a gang. There were things that the jury would have to find before going into penalty.
Not aggravators as to the death penalty,
Sorry.
aggravators as to the gang enhancement itself, Your Honor. That was charged. He was charged in committing the murder for the furtherance of a gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
Yes.
The aggravators with the whole gang bullshit. I've said this over and over. If Melly killed them, this has nothing to do with any gang. The gang is just an aggravator they wanted to add in for the death penalty.
No, objection, that's not true.
That's not correct.
So you all don't agree on that.
No, we don't.
No, what you just said, we do not agree on. There is, I'm sorry.
Have you all done what Judge Murphy ordered you to do?
So Judge Fine or whatever in 23 ordered them to figure out what evidence falls under the suppression order. And apparently they haven't done
The
it.
state appealed it all, which stayed everything. And so at this point, the law on whether or not Judge Murphy was right or not is all up at the fourth, and it stayed. We can't determine that in a stayed case. It stayed.
You can't talk to the state and decide what this applies to?
I just argued what I have to argue, Judge. You're saying it stayed for only one purpose, but not. The answer is we are stayed and unable to do so.
So you don't even know what evidence the order is.
No, I believe we do, and I think that's on appeal at the fourth. But during a stayed case, we cannot do those things. And that's why it hasn't been done. Not because we haven't wanted to. They appealed it. It stayed.
Unfortunately, to also remind the court, the defense did cross appeal, so even stuff that would remain in is also potentially could now be excluded should the fourth rule in the defendant's favor.
And that's still pending before the fourth.
But you don't agree with their request. You want to go forward.
That's what he said.
Sounds like Melly does not want any more delays. He wants the trial to go forward. He doesn't give a shit about anything anymore.
Just 5 minutes. It would take more than 5 minutes, but it can be done easily.
Well, again, and Judge Murphy did this a lot longer than me, but that's what he ordered you to do, 568 days.
Which,
That's
as I
what he ordered you to do. He didn't ask you to do it. He ordered you to do it.
Damn. Both sides didn't follow instructions from Judge Murphy 568 days ago.
But he didn't do that.
And I'll tell
I
you
don't have the benefit of sitting next to him when he went through all of this, so that's why he ordered you all to
And all
say
we would
what
do,
it is.
and all we would be doing is reciting his order. Quite candidly,
Who's arguing at the fourth? That's what I was looking to do with you, David. Who's arguing? So what if their first question is, what evidence are we talking about?
everything from this date to that date.
What date is that? I don't know what all the exhibits are. How would I know that?
That is
You all know that. I don't know that.
that is part of the problem that we haven't even gotten to some of the motions. When we're talking about over 2 million Instagram lines, nothing is delineated that I am suppressing line 1,287,000.
You hear these statements, bro? This is what happens when the state pulls Instagram files and they have to hand over everything, and it's like millions of pages and shit, dude.
Which I have a pending motion that's been pending now for well over a year, probably over 2 years now, or we're approaching that. And that is for the state to delineate what they are intending on using, because if they have 2 million lines of Instagram messages, we can't be prepared for that. Are they introducing all 2 million? Are they introducing just some? And Miss Buckaloo,
Bro, I'm gonna zoom in on the judge's face there. He is so annoyed right now.
let's not hear that motion. We're not ready for it yet because we don't know exactly what we're trying to introduce. So we have not had that heard. So I do not know what specific line the state wants to introduce that would be suppressed by that order, because they have not told us. So all I am left with is that sole period of time. I have nothing else I can say. I can say every Instagram from such and such a date to this date, because I do not know what they're intending on using.
I do find this case to be under the most compelling of circumstances. Mr. Devins, as I sit here today, has been in custody for 2,339 days.
It sounds like he's gonna vacate the stay.
Besides Mr. Devins' cases, which I've removed, this division currently has 38 other cases, special set for trial. 22 of those are murder cases. Numerous of those are death penalty cases. And right now, this division has trials special set through December of 2026, which means any new trial dates I give out will be starting in 2027.
Did you just hear that? He said if he were to delay this September trial, the trial wouldn't be able to start until 2027. There's actually no f***ing way that happens. He's not gonna do that.
Reserve the entire balance of September and the entire month of October to try Mr. Devins' case and Mr. Henry's case.
Oh, he just said that he's already marked off the entire month of September and October for this trial.
So if the defense doesn't object over the state's objection, we are going to go forward on September 10th. The state's motion to reconsider oral order moving forward with September 10th, 2025 trial date is going to be denied.
Boom. Trial's not getting delayed. He's saying no matter what, this should start on September 10th. Thank God. I want this shit over with, bro.
Again, the only thing that would interfere with those is if I happen to be in a penalty proceeding.
What did he just say? Let me see if I can read his lips.
9 o'clock to 12 noon. Again, the only thing that would interfere with those is if
Dude.
In the trial that started tomorrow. I then have September the 5th.
Bro is not happy today. He don't want no more delays. He's snapping at his family, I think. So he just told them we have 20 hours of court before the trial starts, where we have to handle all motions and everything before the trial starts.
For a testimony as it relates to his homicide case, but they're going to go into another area, and that's where we'd be seeking that protection with the in-camera review of the open investigation.
How do you know the questions they have?
Well, they proffered some of them, and I understand what it's like to be a defense attorney. I kind of know where they're going to go, Judge.
Okay, that request respectfully is anything else.
So the court, just clarity, you're refusing an in-camera hearing for the fact that it's an open investigation.
You want me to bring a witness in what, in the jury room, outside of the presence of the public?
Yes. With
Mr.
a court reporter. With a court reporter. This is the guidelines that are outlined under Rule 3220. The court so the court is aware to create a record that there's an open investigation.
They're trying their hardest to give the judge details on why they think it's an open investigation still, and an in-camera review, but the judge is like, no, we don't have to do that.
I can show you the investigation if you want to have a different opinion. That's the point of why I'm asking, just for purposes of the record.
How long would that last? No, I'm not going to argue with you. You tell me this could be ad infinitum. This could be for any in-depth period.
I can discuss that with the court in camera, how long the investigation is going to take, but I'm not prepared to do it in front of...
No, but law enforcement gets to decide that. That's your position. They just get to decide.
Well, it's also dictated by when and how evidence is received, where it leads, how long it takes to get that information, how long it takes to interview those witnesses, et cetera, et cetera.
It doesn't take homicide detectives 18 months. Okay. Hang on. Are you kidding me? You could circumvent the code in 18 months and collect evidence from anywhere you want. That request is, I mean, you didn't file a motion. You're making this in the world.
I don't know who I can
Somebody
find out.
did.
Yes.
Somebody from the state attorney's office signed their name and said, this person has personal knowledge about this case, right?
Yes.
Okay. So the rules are the same here in any other circuit or county court.
Shooting him down. She's a witness. She got to answer all questions at a deposition. Thank God the judge put his foot down. Can you imagine if this judge just delayed the trial to 2027? Hit subscribe. Love you, boys. Peace out.